ladies and gentlemen, gentlemen and ladies and gents, we are going to go to the next one. And yeah, I think we can do this one. So, got something I need to talk to y'all about. Y'all know the song? Y'all know this song, don't y'all? Come on now. Come on now. Come on, everybody. Gotta turn back around. Y'all know the song, don't y'all? See, they don't make music like this no more. And for some of y'all who don't know about the dirty lowdown, y'all need to be recognizing. Ladies and gentlemen and ladies and gents, they be like, what's wrong with you? How come you doing so many videos at 3-4 o'clock in the morning? Because I've been giving something some thoughts. And ladies and gentlemen, I know that many of you are trying to figure your ways around things, through things, and by things. Some of you are in desperate straits because you don't know what to do. You've never faced these stupid situations before, and they are putting a lot of pressure on you. Ladies and gentlemen, what I say is you have to learn their policies, and you have to use their policies against them. The courts, I have somebody, oh God, she just went to court yesterday and she got a discharge of her mortgage. Her mortgage was discharged 2016. Well, they're coming back at her to give a bank who has no claim of title the authority to foreclose on her home. And the judge said yesterday, well, you got the discharge, but this is an NREM proceeding. It's a summary proceeding? This is an NREM proceeding. It's a summary proceeding? And because it's an NREM proceeding, this is about the property. It's ain't about the loan. And she didn't understand what her response was supposed to be. She thought she responded the correct way. She thought she said the right thing, but she didn't. Ladies and gentlemen, hey, boss, hold on one second. Low down. Sorry, y'all know the song. Ladies and gentlemen, bankruptcy and foreclosure are MREM proceedings. Well, technically, a bankruptcy proceeding is not an MREM proceeding. A bankruptcy proceeding is not an MREM proceeding. It is an equity proceeding. The court of bankruptcy operates in equity, does not operate under statute. Okay, that's the first thing. The second thing, her mortgage was discharged. So the bank now needs to show that the property has nothing to do with the debt. Hold on. You guys didn't see what went on? The judge said it was an MREM proceeding and that they could still come after the property. No, they can't. This is about a debt. The debt has been discharged. So if there is no more debt, then there is no more claim on the property because the property was collateral for the debt. If the debt has been extinguished, then there can be no more of a claim on the property. The judge issued an order yesterday and made sure that order was sent out to everybody electronically yesterday. So now she's stressing. I told her, you simply have to do a motion for stay pending appeal. And in your appeal, you have to do a motion for stay. And I said, you just have to bring up the actual logical issues without explaining everything, without explaining how you feel. You just explain what the law says. What does the law say? This mortgage was discharged. The bank has no more of a claim. Now, as I stated before, I'm going to say it again. Many of you who are dealing with the foreclosure process are letting the banks come in without any proof of a debt. Yeah, sure. They bring in a deed and a note and they say, hey, this is proof that the person owes money. Yes, that may be proof that there at one time was a agreement to pay, but you need to come in and prove that it hasn't been paid. Look how long ago that agreement was entered into. So now you need to prove that there ain't been no payment. Okay, how much have you received? Where's your proof that you haven't received it in full? Have you received any funds from any other source respecting this mortgage? Put it on the record. What, you put in a statement? Your Honor, he said he put in a statement. What's the rules on statements in courts? How are statements did? Oh, notarized? Signed under really? Well, look at that statement right there. That thing says it's a statement of accounting. What type of accounting are they doing? Because everybody knows an accounting statement has to be signed by an accounting agent certifying the accounting record. That's why they're called certified accountants. Where's the signature of the accountant? Who did this accounting? It don't got no name on here. There ain't nobody taking credit for this. This is just a piece of paper. That's a piece of paper. I must object to that junk being put into the record as anybody's evidence. That's not even prima facie evidence. It don't even appear to be legitimate. Some of you are going to go back and listen to that and you're going to, oh, wait a minute. I ain't brought that up. My bad. Okay. Ladies and gentlemen, many of you are having the wrong argument with the court. You're letting the court say something and you're being distracted by what the court is saying. Get back to the fundamentals. Hey, this is a foreclosure proceeding, isn't it? Okay, so let them show that they have a right to foreclose. I haven't seen anything on the record that shows that they have a right to foreclose. No, I see documents. Yeah, they showed an old contract. Look how old that contract is. 15 years old. Wait a minute, hold on, Your Honor. 15 years old? Where's their proof that it hasn't been paid? Because I believe that contract has been paid. I don't think I owe that debt. No, I ain't got to prove nothing. No, wait, hold on. Before you open your mouth again and say something that has nothing to do with facts or conclusions of law, it is not my job to prove anything. They must prove it. And they ain't proved nothing. Look at that document. That thing is from 15 years ago. That ain't proof that the debt is still outstanding. That is proof that there was at one time a debt. So now they have to prove that the debt is still outstanding. Okay? Y'all know the word outstanding. Okay, so if they want to knock you out, they better prove that that debt is still outstanding. Just that simple. That's the first thing. The second thing, Your Honor, hold on a minute. Where's a statement of accounting? Well, we know that a statement of accounting must be certified. You can't just put in a piece of paper. Go ahead and look at the statement of accounting that they send you every month. Tell them this is a piece of paper. Ain't got no signature, ain't got nothing on it, just a bunch of numbers. Look, here's my statement of accounting. Mine got a signature on it. Look, I don't owe you nothing. So no, you're going to send me a statement of accounting that is certified by your certified accountant. We ain't going to play that. Y'all not going to be just bringing no junk up in here. You guys have got to start speaking up. Don't argue with nobody. Say simply, judge says something. Excuse me. I'm sorry. What are you saying that based upon? What law? No. That's a statute. Statutes are not law. Well, no. Excuse me. Are you rebutting what I just said, that a statute is not law? You must be out of your mind. You are a judicial officer. You know better than that. You know that statutes are prima facie evidence of nothing. Prima facie means appearance of. It doesn't mean actual. So statutes are not law. They have never been law. So I need you to rely on the law. Is this a court of law? Wait, hold on. Let's get this on the record. Is this or is this not a court of law? Yes or no? And if he says anything other than, I said, is this or is this not a court of law? Yes or no? Then you need to hold yourself in contempt. Ladies and gentlemen, you guys don't understand, do you? Judge can't avoid answering that question. It's a matter of public interest that he asks her that question. He says he has jurisdiction. She says she has jurisdiction. Then prove your jurisdiction. Is this or is this not a court of law? Yes or no? Doesn't matter if they get upset. Doesn't matter. You're asking a legal question in a so-called legal venue. They cannot avoid answering the question as to whether or not they're a court of law. And that cannot be explained away. They have to prove that they're a court of law, not a court of statute. All right, ladies and gentlemen, as I told all of you, and you really must understand this, the Non-Judicial Foreclosure Act applies to secured loans. Your loan is not a secured loan if your loan was approved and you used your approved loan to go purchase a home, and the bank took the loan and paid the the old homeowner. They paid them for the home and then gave you the keys. That's called after acquired collateral. After acquired collateral cannot be construed as a secured loan. It's after acquired collateral. That means the loan was not secured. Hold on. The agreement may be secured by the collateral. That's fine, but that's a personal loan. That's not covered under the Non-Judicial Foreclosure Act. I want you all to pay attention to me. I've never read this in the Non-Judicial Foreclosure Act. What I can tell you for a fact is I know that even if it is covered in the Non-Judicial Foreclosure Act, which it is not, guarantee you it's not, and I dare anybody to prove to me that the Non-Judicial Foreclosure Act covers after acquired collateral. Because the word secured and secured loan means exactly that the loan was secured upon issuance. In other words, that there was collateral backing the loan from the very beginning. That is not the case. You go to the bank, hey, I need to get a loan. We're going to need to run your credit check. We're going to need to know your credit history, and we're going to need to know your employment history. Make sure you're able to pay the loan back. Oh, no problem. Can you get that paperwork to us? Oh, yeah, no problem. Here you go. Wait, we're missing this statement right here, and we need a copy of your taxes. What you need a copy of my taxes for? To make sure you've been filing taxes, because the IRS want to make sure you paying your taxes. The IRS want to make sure I'm paying my taxes. What about you paying your taxes? Oh, they ain't worried about us paying taxes. We don't never pay taxes. You don't never pay taxes? Oops, I'm sorry. I wasn't supposed to say that aloud. Don't write that down. What, you recording me? Oh no, I'm just gonna deny that. I'm gonna say we were talking about something else. The whole conversation. Okay. Well, okay. Well, I'm gonna have to ask you to leave our offices. Yeah. No, you're not welcome here anymore. Y'all need to pay attention to what's been going on. They're foreclosing your house in a non-judicial state. We are now before the appellate court for the Federal Circuit in Washington, D.C. on the issue as to whether or not the in rem proceeding is a summary proceeding and you have the right to ask for summary judgment. You see, that's the one thing the young lady in that proceeding did not do. She didn't ask for summary judgment based upon the facts. Ladies and gentlemen, you can ask for a summary judgment based upon the facts, and you just have to document what those facts are. That's it. Summary judgment based upon the facts, because the facts show that there is no controversy. Now, we're going to let my boy play in the background so that y'all know where we at right now. Now, like I said before to y'all, there is a whole issue of people trying to figure out how to get through this whole maze, figuring out how to get through their lives. And so those of you who are going through a non-judicial foreclosure, do not think that it's the end of the world, because it is not. Do not think that just because they come up with a ruling, you all must really understand what a ruling is. Judges don't make law, ladies and gentlemen. What they want is for you guys, and I'm going to turn my boss tag down because they are wondering. Here's the problem with many of you, and it is disturbing to me that many of you are not figuring things out, so I have to point it out to you. Y'all don't mind if I point it out to you, because it's 100% absolutely necessary. Many of you do not know law. and you're going into court trying to sound like lawyers, and you're bringing in all that junk that you've heard on videos. Ladies and gentlemen, you don't bring up junk that you heard on videos, not even my videos. You go and you do your own research. I had a young man try to reach out to me, and I've spoken to him before. His name is Bruce. And Bruce, I'll be giving you a call soon. Sorry, y'all, my life has been hectic. I ain't been able to call a lot of people back. But I will tell you guys so that you guys will understand what's going on, because it's 100% necessary that you understand what's going on. There's a lot of stuff going on. Okay? I'm trying to help so many people at one time. I was only one person. Okay? And the fact is, I keep hearing people talk about their eyes being open as they listen to my videos. Ladies and gentlemen, that's the point. And all you got to do is do the research and prove it for yourself. Now, I show you proof of everything I say on video. But all you got to do is prove it to yourself. Go look. Don't just take my word for it. What if I sat up there and altered each of those Google searches and have an algorithm that makes it say what I want it to say? Ladies and gentlemen, we're going to do one more song. And that's the reason why I left it on the screen, because we want to go a long way back. Y'all know what I'm saying? Hey, Bloodstone, could you tell them? There you go. Dun, 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 dun. You and me, girl. Where we go? Go a long way back. Such a long, long way. Oh, I'm so proud, y'all. And I'm so proud. Yeah. Sorry. This song right here, it took me a long time to find. I didn't know who sung it. And so I'm breaking my neck to find this song. And when I finally found it, y'all better believe I made at least 8 different copies of it, because I didn't ever want to be without this song. We go a long way back. Now let's go ahead and bring this to a close. There are so many of you, as I said, who are getting ready to almost lose your home. When I say almost lose your home, in a moment, each one of you who's had a mortgage for over 20 years, doesn't matter if you refied, each one of you who've had a mortgage for over 20 years, I'm going to be having you give me a contact, and I'll tell you how. Not now. You're just going to have to pay attention. I'll call the video 20-year-old mortgage. So when that happens, you'll have a means of contacting us, and you will be our primals. It will probably be 20-year-old mortgages, but I'll also include 15-year-old mortgages in that. Doesn't matter if you refinanced 5 years ago, last year, 2 years ago. You're the ones that are going to be contacting me. We have a program for you to help you keep your home. Not ready yet. Some of you are going to want to be contacting me and emailing me. Look, ladies and gentlemen, there are some of you who are commenting on my videos and my emails. I don't want you commenting on my videos and my emails. You do it again, and I'm only going to give this warning here. I'm not going to give the warning on the email. I'm just going to block you. I'm not joking, not kidding. The comments are all for a reason. I don't want your opinion. I don't need your opinion. Oh, you hurt my feelings. Well, you better hold on to some glue so that you can stitch your feelings back together again, because I will pulverize your feelings. You keep with me. Okay? When I tell you something is not allowed and you do it anyway when it concerns my property, my business, my interests, then you must be out of your mind if you think you're going to do what you want to do when it comes to my stuff. I'm sorry. I'm sorry. Some of y'all don't understand. I don't play that. Not when it comes to my stuff. Now, let's get back to this mortgage thing, ladies and gentlemen. Like we said, 15, 20-year mortgages, possibly, I don't think more so 10-year mortgages, because 10-year mortgages, the original mortgage is what we're talking about. We're not talking about the current mortgage. We're talking about if you've been in your property for 15, 20 years, you're the ones that we're going to be looking for. Okay, I just need y'all to understand. I need you to wait on me. You just need to wait. Look, I'm not the mortgage person. I'm not the tax person. Okay? So I have to organize this before I bring it your way. or then you'll just be beating your feet against the pavement like the Flintstones used to do, standing in place. We ain't gonna be doing that. We're gonna stump the yard. Okay? Ladies and gentlemen, those of you who have other mortgages, we have another program for all of you, not just the 2015 year mortgages, but for everybody who's got a mortgage. We have another program that we're putting together. Well, technically not me. The young man I told you about is starting up. Listen to that right there in the background. There you go. I want to thank you, girl. Because we go where? A long way. All right, ladies and gentlemen, that gentleman and I are working together to put together that program to help each one of you. However, we are trying to figure out the best way to do it because we're not trying to shut the system down. Y'all just need to trust me for the moment that that's the aim. All right, we will keep you apprised and we will keep you updated as best we can. Those of you who have the SAP packs, we're getting ready. The newer SAP packs, that is a stage thing. We have to wait till we have a certain number in order for us to go to the next stage. The only thing you need to do is hold on to your paperwork. Ladies and gentlemen, we are getting ready to start issuing the bonds for the previous SAP packs. I just need y'all to hold on. Do me not inquiring because you're just going to slow us down. We're going to get it taken care of. I need y'all to walk with us, not walk against us. Y'all feel me? Gotta go. Y'all take care. Y'all get on with your lives, people.